Chairman.
My Lords, I appear in this matter with my learned friends Mr Hoffman and Mr Fraser for the appellant. My learned friends Mr Howard, King's Counsel, Mr Scott and Mr Bell appear for the respondents. My Lords, the principal issue in this appeal is whether the Court of Appeal was correct to disturb some, but by no means all, of the trial judge's detailed findings as to valuation, based on the lay and expert evidence adduced at trial, substituting findings of its own. And my Lords will know that in our submission, while identifying the principles applicable to when an appellate court should interfere with the findings of a trial judge, the Court of Appeal then failed to apply those principles, such that its decision provides another stark example of the dangers of unjustified interference on appeal with the detailed and careful findings made by a judge at trial. By way of introduction, can I just identify and outline what the effect of the Court of Appeal's decision was? My Lords will know that the judge decided that he would give most weight to the market-derived valuation methodologies and afforded 75% weighting to the merger price and market price, and he gave the least weighting to the DCF valuation methodology of 25%. The effect of that, once he had then given 45% to the merger price of $11.60 or $11.37 after applying the minority discount, and 30% to market price, $7.41 and $7.26 after applying the minority discount, and the 25% to the DCF valuation, $18.17 and $17.81 after the minority discount, was to produce a fair value of $11.99 or $11.75 after minority discount, a fair value which is, of course, very close to the agreed merger price of $11.37 after the minority discount. Now, the effect of the Court of Appeal's decision was as follows. First of all, the Court of Appeal decided that merger price could not be relied upon at all and reduced the weighting to that valuation methodology to 0. Secondly, the Court of Appeal held that the judge could not be criticised and was not wrong to have given a 30% weighting to market price. And it then found that accordingly, the DCF valuation methodology should be increased from 25% to 70% in order to produce fair value. And beyond that difference to the weightings afforded to the different valuation methodologies, the Court of Appeal also made 2 further adjustments to the DCF valuation methodology, which are the subject of grounds of appeal 4 and 5, and to which I'll come. My Lords, the effect of that decision is first of all to give primacy to the DCF valuation over the market-derived valuation methodologies without explaining why that is justified, other than, so as to speak, to fill the gap left by disregarding the merger price. The second effect of that decision was to overturn completely the judge's primary weighting given to the market-based valuation methodologies. But reversing the judge on this aspect of his decision is, with respect, neither explained or reasoned in the Court of Appeal's decision. And the third principal effect of the Court of Appeal's decision, my Lords, is it was to overturn, in effect, the judge's finding that he generally preferred the expert evidence of Miss Glass, the expert called on behalf of the company, who gave primary weighting herself to the market-based valuation methodologies over the DCF valuation methodology. And again, the effect of that decision to effectively overturn the judge's preference for Miss Glass's evidence over the evidence of the petition of the dissenting shareholders, expert Mr Edwards, is not addressed in terms in the Court of Appeal's reasoning. And my Lords, we do say it's significant to consider what the Court of Appeal did not find. It did not find in terms that the DCF valuation methodology should be given primary weighting or identify any rationale for that outcome. And that's notwithstanding that the Court of Appeal increased the weighting afforded to the DCF valuation methodology by a factor of nearly 3 times. Nor did the Court of Appeal find that the judge was wrong to give primary weighting to the market-derived valuations, or that the judge was wrong to prefer the evidence of Miss Glass over that of Mr. Edwards. And, my Lords, finally, perhaps by way of introduction, looking at the effect of the Court of Appeal's decision, the Court of Appeal did not step back and assess whether the judge's overall conclusion was likely to be wrong in the relevant sense by comparing it with the likely overall valuation produced by its approach, having interfered in the way that it did with the findings that had been made by the judge at trial. And, my Lords, will perhaps understand from the chronology that the matter has not yet come back before the Grand Court for a final determination of fair value applying the findings of the Court of Appeal, but perhaps I can update my Lords to this extent. In the context of an application for an interim payment, a further interim payment, the expert's position has reached this, namely applying the Court of Appeal's findings. Miss Glass now produces a figure for fair value of $16.39, and Mr. Edwards a figure of $18.38, from which my Lords will immediately see that those figures, whichever of them is taken, represents a very significant increase on the figure as found by the judge of $11.75. And indeed the merger price of $11.60. And finally, perhaps to provide something more by way of context, my Lords would have seen perhaps from the judgments that the DCF valuation methodologies, certainly insofar as Mr. Edwards' expert evidence was concerned, gave rise to wildly different valuations, ranging from a little under $10 through to the intermediate position of $50, through to his top position of $197. And to put that in some sort of context and using round figures, on the basis of the merger price, this company was valued at in the order of $1.1 billion, whereas on Mr. Edwards' DCF valuation methodologies, his midpoint would value the company at something in the order of $5 billion, and his high point would value the company at just under $20 billion. So that's the type of varying result that the DCF valuation methodologies gave rise to. My Lords, can I turn next and deal, I hope, relatively briefly with that which I think is not really in dispute, which is when is it that an appellate court is entitled to interfere with the findings of a trial judge? And in this context, I was perhaps going to just draw attention, if I may, to 6 or 7 points by way of emphasis, because as I say, the relevant principles do not appear to be in dispute and appear to have been identified.
I think you might assume that we're quite used to applying them by now.
Well, my Lords, I'd rather took that as read as well, but it may just be worth, and I will be very brief and won't, unless my Lords wish me to, turn up the relevant authorities, identify the points upon which we particularly rely before we actually turn to see what the Court of Appeal did. The first and overarching point, of course...
Did the Court of Appeal go wrong in their citation of the principle?
My Lord, no. It's the application of those principles. We may quibble slightly about whether what the Court of Appeal said about an appellate's role when reconsidering expert evidence is quite right, but that's really around the margins. It's really around the margins. And my Lords will understand that we say when one looks at the test, namely that the appeal court should not be interfering unless the judge can be shown to have been plainly wrong, in the sense of making a decision that no reasonable judge could have made. And when one looks at the very careful findings of the learned judge here, that test with respect to the Court of Appeal was not set out. Was not made out, forgive me. Those requirements before an appellate court can interfere have rightly been described as very stringent, with the result that interference should be rare. And of course, questions as to the weight to be given to evidence is preeminently a matter for the trial judge. And I'll make this point because it informs some of the submissions that will come. As we know from the Farge case in the English Court of Appeal and the judgment of Mr. Justice Lewison, part of the rationale for this approach is that the trial judge has regard to, as he put it, the whole of the sea of evidence presented to him, whereas an appellate court will only be island hopping. And one of the real difficulties with the Court of Appeal's decision in this case, my lords, with respect, is the hopping from island to island and losing sight of the overall picture. And I've indicated already in answer to my Lord Hamlin, while it may be slightly easier for an appellate court to reconsider expert opinion when compared to the testimony of a lay witness, the same caution and the same test applies to whether the appeal court is justified in interfering. And we do say, finally, that caution perhaps applies all the more so in valuation cases of highly technical and complex factual matters, as we have here. And we've given my lords the reference to Capita in the English Court of Appeal and the judgment of Lord Justice Gross, where he identifies that the very nature of valuation and the inherent exercise of judgment and evaluative exercise in that judgment makes it all the more difficult to interfere in a trial judge's findings.
In your cases, the Court of Appeal should not have held the judge was plainly wrong.
Essentially, my lord, that's it. Yes. That's exactly it. Now, with that said about the test, can I then next briefly identify one or 2 points about the nature of Section 238 proceedings in particular, as that may inform some of the submissions that come next. The first point, perhaps, to draw attention to is this curiosity, which is that the dissenters, having filed notice of dissent pursuant to the statutory provision, Section 2382, the company then brings the petition before the court. But in doing so, there are no pleadings as such from either side. So as a result of that, the company does not learn of the dissenting shareholders' essential case as to what fair value of their shares is said to be until the receipt of expert reports, which is often only shortly before the trial itself. The standard directions that have developed as a matter of practice in Cayman now require substantial discovery from the company, but discovery not assisted in the usual way by the pleadings. Expert evidence is invariably required and permitted, and certainly the experience to date has been that this has led to lengthy trials. Here, something like 16 days before the judge, with over 9 days of evidence, and indeed 3 days before the Court of Appeal. Other relevant features which appear in some but not all cases, but certainly appear in this case, is first of all that the shares in question will often be listed on a market. Secondly, the merger will have been approved by other shareholders. And thirdly, that the merger itself will be subject to some sort of internal consideration and cross-check or review by the company itself before being put to the shareholders for approval. Beyond those general features of Section 238 proceedings, there are perhaps some specific features of this case to which I should briefly draw attention. The first is the length of time that these proceedings have occupied. So the merger was approved on the 16th of December 2016 and completed on the 13th of March 2017. The petition was heard in May 2019, with the judge giving his judgment in September of 2020. The appeal was then heard by the Court of Appeal in May 2022, with judgment being delivered in May of 2023. And here we are now in July 2025, some 9.5 years after the merger was approved. The second feature of this case is that the overwhelming majority of the shareholders voted in favour of the transaction. So 97.8% in favour and only 2.2% against, while the buyer group itself had a relatively small minority interest of just over 5%. And that's obviously something I'll return to when one looks at the factors relied on by the judge as supporting reliance on the merger price. And the third point is that, and perhaps not unusually or unique to this case by any means, the dissenters acquired their shares after the merger proposal had been made. What then is to be taken from those features? In our submission, they are relevant or likely to be relevant in a number of respects. First, as regards the approach to valuation issues, as the judge correctly found, unless there is reason to doubt their reliability, one should start with and give substantial weight to the market-derived valuations, here market and merger. That approach gives due recognition to the fact that absent material non-public information, MNPI, an efficient market should provide a reliable guide to fair value and a more reliable guide than a judge's evaluation of competing DCF valuations produced by the parties' experts after the event. It also pays due regard to the principle that, generally speaking, the court should not be second-guessing the decisions of management and shareholders of a company. And one of the many problems with the Court of Appeal's approach in this case, and the outcome of that approach, is it suggests that the market and the company's other shareholders, including its very many institutional shareholders, effectively overlook the bargain of the century. And that suggests in and of itself, in our submission, that something very seriously has gone wrong with the Court of Appeal's approach. These features of the Section 238 jurisdiction are also, in our submission, relevant to the approach to be adopted on appeal. Firstly, because valuation, and we see it here in particular, is a multifactorial exercise in evaluation. It is, as often been said, an art, not a science. There are complex issues of fact with which the judge had to grapple. Those complex issues of fact were subject to detailed consideration at a lengthy trial by an experienced and specialist commercial judge. And so we do say that the appeal court should be particularly slow in those circumstances to interfere and really has to identify with precision how it is and in what respects the judge has gone plainly wrong. And the final point, Lord, arising from this context of the Section 238 procedure is that it does demonstrate the particular dangers of island hopping. If you interfere, as the Court of Appeal did, with one or even two islands, you risk changing the entire landscape on the map without necessarily understanding that this is the effect, still less justifying that this should be so. And we say, in essence, that's what the Court of Appeal in this case did. So, my lords, with those introductory and contextual points having been made, can I deal next with our first ground of appeal, which concerns the significance and reliability of the merger price?
I find the whole approach by both courts quite odd because it involves combining a market valuation with a discounted cash flow valuation, but in the case of the Court of Appeal, it's about 3 times as much. And they can't both be reasonable values. So either you think the market valuations are roughly right, you might adjust those, or you don't, in which case you don't use them. But to go about mixing together incompatible valuations doesn't seem a very rational way of arriving at an accurate value.
Well, my lord, With respect, it's very difficult to say anything by way of challenge to those propositions. I mean, what I would say is this. The judge clearly had in mind that what he was doing was giving primary weighting to the market-derived valuation methodologies, and then, as he put it, using the DCF valuation as a cross-check. Now, as it happens, he's used it not only as a cross-check, but by giving it some valuation weighting as well. But at least on his approach, the three figures coalesce around about the same range and produce a fair value that is within striking distance of the merger price. So one can see that the analysis, so to speak, holds together. Mm. The difficulty with the Court of Appeal is that while one can provide that rationale and explanation for what the judge did, the Court of Appeal was then faced with the stark choice between market price at around $7 and DCF at $18.
Well, on their case, on their approach, went up to about 22, I think.
It did. Even higher, although they didn't work that out for themselves, obviously.
They would have realised that it was going to go upwards.
Yes. So you've got a position where, exactly as my Lord says, the Court of Appeal is combining, seeking to merge one valuation, which is 3 times the size of the other. And as my Lord says, they both can't be right. And one sees no consideration of that process in the judgment. One sees no comparative evaluation of the valuation methodologies in the same way as you saw with the judge, where he looked at the three together and decided how they should be adjusted and used. You instead have, jumping ahead somewhat, the Court of Appeal saying, well, we're going to say the merger price is unreliable, so you knock it out. No one's suggesting that we should do anything with market price, so that stays at 30%. So we just increase DCF to 70%, and hey, that's the result. But it's unprincipled, and in our submission it's wrong. So, my Lords, looking first of all at the basis upon which the Court of Appeal sought to interfere with the judge's decision on merger price, in our submission there are really 4 bases upon which the Court of Appeal differed, and I'll have to deal with 2 rather more than the other 2. The first is the cost of debt used in the City Fairness opinion, which the Court of Appeal found to be too high, and as a result discounted any reliance on the City Fairness opinion itself. And I'll have to say some things about that. The second point is what I've called the NDA point, the non-disclosure agreement point, where the Court of Appeal differed from the judge as to the difference that may have made, but ultimately concluded it probably didn't make too much of a difference at all to whether you could rely on the merger price or not. Similarly, they differed from the judge on what we've described as the Norcraft point and the judge's interpretation of the Delaware decision in Norcraft. But again, the Court of Appeal concluded that ultimately that made no difference because he was right, the judge, in identifying what the principle was, which is that even if you identify flaws in the merger process, you can nevertheless place weight upon it. And the fourth point of departure was the Court of Appeal's assessment of the other deficiencies in the merger price process. Now here, in our submission, the Court of Appeal simply identified all of the same deficiencies in the merger process that the judge had identified, but decided they ought to have been given greater weight. And I suppose, for completeness, the difference in approach also extended to the Court of Appeal's assessment of the countervailing factors considered by the judge as ultimately outweighing the deficiencies and defects in the merger process, including, as I've already touched upon, the large vote in favour of the merger by sophisticated institutional shareholders. And as we'll come on to see, the Court of Appeal was somewhat dismissive of that, suggesting that those features were likely to be present in most cases and therefore did not weigh terribly heavily in the balance. There's one final point to which I'll perhaps return, which is that the Court of Appeal also sought to justify its approach and ultimately its decision in paragraph 148 of its judgment by identifying the need for a deterrent effect and perhaps it is just convenient, as I've mentioned it, to turn it up now. It's paragraph 148, which
Page.
it's page 118, tab 4 of the key documents bundle. It begins at the bottom of page 118, and having identified the various deficiencies, as the Court of Appeal saw it in the merger process, one sees the conclusion in the penultimate line that no reliance could be placed on the merger price. And then over the page, we get what I've identified as the additional reason for adopting the approach that the Court of Appeal did, beginning 6 lines down, and the sentence furthermore, if despite.
They've already concluded that you can't safely rely on the merger price.
That they have, and then they add this additional reason, which is the deterrent effect, if I can put it that way, i.e. that if weight can be placed on the merger price in this case, notwithstanding the deficiencies that the Court of Appeal has identified, there's a risk in future that companies will behave in a similar manner and not be open and transparent about all relevant evidence. Now, Lord Hamlin is obviously correct with respect to identify they've already reached their conclusion, but to the extent that that is providing a further reason for that conclusion, in our submission it's a bad one. But it is perhaps a window on the Court of Appeal's thinking. So, my lords, can I move then to cost of debt? And I'm sorry.
Why precisely is it a bad point, do you say?
Well, either merger price can be relied upon in this case or not, for reasons to do with its inherent defects and advantages. The idea that you can justify not relying on merger price because of a need to deter companies from not complying with their discovery obligations in the future is not a good rationale or a principled rationale for disposing of reliance on merger price.
You.
So, my lords, moving to cost of debt, in our submission with respect, this is a classic case of island hopping. The first point to be made here is that the cost of debt was but one part of an analysis primarily directed towards the calculation of the weighted average cost of capital, WACC, WACC, which was itself just one part of the analysis in the City Fairness Opinion, which was itself just one factor to be weighed in deciding what, if any, weight could be given to the merger price. And as correctly recorded by the judge, the challenge to City's cost of debt was but one part of a challenge made by the dissenters to its calculation of the company's cost of capital. And one sees that from the judgment at paragraph 153, Roman 4, on page 318.
Sorry, paragraph
153, Roman 4, on page 318. And one sees that in that paragraph, forgive me, it's 153b, Roman 4, but in 153 A and B, one sees the various other challenges that were being made to the City Fairness Opinion. So the first point to note is it is only an element of the WACC, which is an element of City's DCF calculation, which is an element of City's fairness opinion, which is one factor to consider when considering whether the merger process was robust enough such that reliance could be placed on the merger price. Having found that the cost of debt figure used by City was too high, the Court of Appeal appears to have concluded, although it's not entirely clear, that no weight could be given to the City fairness opinion at all. And beyond that, my lords, the Court of Appeal's focus on the cost of debt figure ignored the holistic approach to the evidence on this issue, the reliability of the City fairness opinion, which was adopted rightly by the judge. So the first point to note there is that the judge found that even if the 13% cost of debt figure used by City was high, this might have been justified. And Miss Glass, whose evidence he generally preferred and whose evidence he preferred on this issue, gave a potential justification for this, which was recorded by the judge in his judgment, namely that City's assumption of a very high capital structure, which itself suggested an assumed leveraged buyout, was the rationale or explanation for the high cost of debt. And also...
Is that a complicated way of saying that a lot of money was going to be borrowed to buy the company?
Yes. And in fact, that was not an accurate assumption as things turned out. City assumed 70% or so debt, whereas the true figure was nearer 50, which is what the experts used. But what Miss Glass was identifying is that if it was a leveraged buyout with that higher level of debt, then that might be an explanation as to why the debt would be more costly. But as we will come on to see, that was balanced out by other assumptions that City made, which had the effect of correcting the weighted average cost of capital, so that their overall conclusions were very similar. The conclusions reached by City and the conclusions reached by Miss Glass.
The actual debt that was going to be taken on was known to the City valuer.
I think that was probably right by the time, obviously, that the merger was approved by the company. But whether it was right I think it must have been right when the City opinion was produced. Whether it was known at the time the underlying calculation was produced, I think perhaps is not so clear on the evidence. But it was certainly the City opinion refers to the level of debt.
I thought they were contemporaneous. I thought what the Grand Court called the market analysis document was presented at the meeting on the 1st of August. That's right. Which was the same date that the opinion was given.
That's right, my lord. Whether the analysis had been prepared as I think it was earlier and hadn't been updated, one doesn't know. But it's certainly true that the City fairness opinion identifies the actual amount of debt being taken on, whereas its model used for the DCF calculation assumes a much higher level of debt and a higher cost of debt. And what Miss Glass identified was, well, that might be an explanation as to why the higher cost of debt figure was being used. She didn't know that that was true because the experts had not been given City's model, but that would provide an explanation, as too would be an assumption of a greater need for restricted cash and the cost of restricted cash. So Miss Glass had proffered two potential explanations as to why City was using a higher cost of debt than she was, without quite properly going so far as to say that that was the explanation, because she hadn't been able to interrogate City's model or ask anyone from City whether that was or was not the explanation.
Sorry, can you help me with the two reasons she gave?
The first was a very high capital structure. So that's more borrowing than was in fact undertaken, and indeed more borrowing than the experts assumed. And the second, but related reason, is the need for restricted cash and the cost of having restricted cash.
Are those reasons, if they were right, would they result in sort of opposite effects, so to speak, or not? And if they wouldn't, then it doesn't seem to me relevant, really.
Well, they have a...
You see what I'm asking? I mean,
yes.
They had some offsetting effect, which would mean that if that assumption was wrong for that reason, then it would make nevertheless the overall valuation more likely to be reasonable for other reasons.
The answer to that particular question is no, is that those reasons as to why a high cost of debt may have been taken do not provide an offsetting effect. What does provide an offsetting effect is, the second reason doesn't. What does provide an offsetting effect is the higher amount of debt, the higher proportion of debt, because debt was cheaper than equity in Citi's model. And that's why in the event, when Miss Glass reran Citi's model, she in fact came out with, first of all, a very similar valuation to that reached by Citi, around $11. But secondly, it's also why, albeit that they've taken different assumptions, Miss Glass's weighted average cost of capital was very similar to Citi's, even though they'd used very different costs of debt. She'd used a lower cost of debt, but a lower proportion of debt, so that there was greater equity and a greater cost of equity. So there was that cancelling out. And one sees that the judge identifies these potential explanations at paragraph 170b, which is page 331. One sees there the judge recording evidence which ultimately accepted that Miss Glass could not say that it was an error to take 13%, and then one sees the potential explanations as to why that had been taken, given in that paragraph. And one sees, importantly, and this is the balancing figure, or the balancing point, the judge recalled Miss Glass's opinion that the 13% might be justified, and then importantly, the overall result of Citi's DCF valuation appeared to her to be reasonable. So she was not prepared to say that Citi had made an error, let alone a serious one. And that then is explained further in paragraph C, and in particular the last sentence, that when the model is viewed in the round, the use of the 13% cost of debt did not result in a material undervaluation. And it might just be helpful, my Lords, if I show you some of Miss Glass's evidence upon which those conclusions by the trial judge are based. If we can go to the electronic bundle, please, at page 5113. Towards the bottom of 5113, there's a heading, Citi's cost of debt and size premium assumptions. And at paragraph 185, Miss Glass deals with cost of debt. And if perhaps I just invite my Lords to read paragraphs 185 through to 187.
5113, paragraph 185.
Yes, it's at the bottom of page 5113, my Lord. There's a side heading, cost of debt, at paragraph 185, and it's 185 to 187.
Yes.
Lords will see those paragraphs effectively set out the gravamen of the submission I've just been making, including as to the balancing or countervailing effect of different assumptions. And importantly, of course, this is what the judge meant when he was viewing the model in the round. The City and Miss Glass may have taken different assumptions, but ultimately they reached a very similar figure on weighted average cost of capital and very similar conclusions on the DCF valuation. So you can't just cherry pick and say, well, that one assumption, cost of debt, seems high, therefore you throw out all of the analysis and place no reliance upon the City fairness opinion at all. But that's what the Court of Appeal did. There are two other paragraphs in the judge's judgments which I should draw attention because they are important and they are not conclusions reached by the judge that were referenced by the Court of Appeal when overturning him on this point. And they are paragraphs 174 and 175 of the judge's judgment at page 333.
What information was known about City methods? I mean, their actual opinion doesn't say anything about them, I don't think.
The opinion...
Say methods, I mean the assumptions that they made.
Some of the assumptions are clear from the analysis. So, for example, the 70% debt ratio. But as Miss Glass fairly acknowledged, one could not get to all of the assumptions used in the City fairness opinion model, or rather the DCF model included within the opinion, without having access to either the model or City themselves. But Miss Glass was able to proffer the potential explanations that she did based on what was known about the contents of the model.
But is the entire information that the three-page document that we were supplied with as an additional document, was there more than that?
The three-page document that my Lords were provided with separately was the opinion.
Yes.
Then underlying the opinion there is the calculations which begin at page 1813.
Sorry, page?
1813, my Lord.
1813.
1813, thank you.
Which is the slide deck presentation to which my Lord Justice Popwell referred to.
I see. So that was the main source of information about what they'd done.
Indeed. And one sees that it wasn't just the DCF calculation they were undertaking. They were doing rather more by way of valuation analysis as well. But one sees, for example, on the DCF valuation at page 1824, on the left-hand side of the DCF valuation, we'll also see the heading Key Assumptions.
I see.
Yes.
And that includes cash, total debt, and one sees there the WACC of 11.6%, which we've seen reference to in both Miss Glass's evidence and the judge's judgment.
Okay, thanks.
So, returning to the judge's judgment, paragraphs 174 and 135 are in our submission important because this provides further explanation of what the judge meant by viewing the position in the round, namely moving from the particular focus on the cost of debt figure of 13% and actually giving a broader consideration of the City DCF valuation in the round, including by reference to the exercise that we see that Miss Glass did, referred to in paragraph 174 of the judgment, which was rerunning City's analysis using her own model, which produced, as one sees there, a very similar fair value. And that then leads into his conclusion at 175 that it is not possible to conclude that the fairness opinion was subject to errors of a methodological or arithmetical kind that made it unreliable and unreasonable. And with respect, the Court of Appeal simply seems to have overlooked this part of the analysis and instead focused in a way that all the appellate authorities and the well-established principles tell us that they should not have done, on one particular finding on the cost of debt figure. And in fact, just how...
I don't have a, we can't get into the detail of this case in great depth, and I don't have a handle on, did the analysis that Ms. Glass did, was that irrespective of the cost of debt, so to speak, so that the cost of debt didn't influence the figures that she adopted?
Yes, she just took the discount rate, the weighted average cost of capital of 11.6%.
But one factor of that in how Citi had calculated that was the cost of debt.
It was, but she instead was saying, we'll leave that on one side, let's just take the WACC as calculated by Citi, however it was calculated.
I thought she's saying that it's saying here that she applied Citi's discount rate of 11.6.
Yes, that's the weighted average cost of capital of 11.6%. So she's taking Citi's figure, however they've got to it, run their figures through her model, and produced a DCF valuation that's very close to her own, which gives her comfort that, as she put it in her evidence, both in regards to Citi and as regards management projections, there may be pluses and minuses where one might take a different view, be it to Citi or the company. But overall, the pluses and minuses cancel out.
Okay.
And the overall test is, well, is the product reasonable? Rather than to focus on individual elements and then say, oh, well, if that individual element can be challenged, then the whole analysis goes. And the judge was, we would say, right, and the Court of Appeal wrong, to look at the position holistically and in the round, rather than to focus on particular component elements or sub-elements of the analysis. And my Lord, finally, perhaps on this point...
and that's looking at it in the round is 174 to 175.
Yeah, well, it begins, yes, it's what the judge uses the phrase in the round at 170C, and then the further explanation of what in the round means is 174 and 175.
Thank you.
Could I just ask you to pinpoint where in the Court of Appeal they dealt with this? Which paragraph? Have you already taken us to them? You may have done.
I'm not sure I have, but 146... at page 118, Roman 9, yes.
It's just one of the factors they relied on.
146 is a very long paragraph.
It's a very... It's Roman 9 on page 117 and into 119. So this is one of the factors they rely on in discounting the merger price altogether. But it's implicit, or would appear to be implicit, that in saying and finding that Citi took a cost of debt figure which was too high, that effectively no reliance could be put on the Citi fairness opinion at all when it came to considering whether merger price could be relied upon at all. So it's a parasitic effect on the challenge to the cost of debt. They don't, with respect, say so in terms that they're disregarding Citi altogether, but that seems to be the effect of what they're saying. And we would respectfully suggest that this paragraph demonstrates quite how badly the Court of Appeal went wrong, because it is a point against the analysis and conclusion that's reached in this paragraph rather in support of it, that the Court of Appeal notes here that if you substitute Mr. Edwards' cost of debt figure for Citi's cost of debt figure, then that, if you didn't adjust anything else, would have doubled Citi's estimate of fair value on the basis of its discounted cash flow valuation. Now, the Court of Appeal seems to have regarded that as demonstrating that Citi had gone awry. Whereas if one recalls Miss Glass's approach and the judge's approach of looking at the position in the round and looking at all the various inputs, this, in our respectful submission, shows how wrong the calls for appeal were going. How credible was it really that if you adjusted that one input in Citi's DCF analysis, the value of the company would be doubled?
Do you place any reliance in this context on the DCF valuation being one of only two methods that Citi used to reach their fair value figure, the other being prices on a price earnings basis of competitors and others in the market? Is that not really relevant to this?
It's not really relevant to the way that we put the challenge to the Court approach model, other than by way of further illustration that what Citi was doing was not just producing a cost of debt figure, it was producing a cost of debt figure for a weighted average cost of capital figure as an element of a DCF valuation, which was itself was then cross-checked with another valuation methodology. And yet the Court of Appeal goes from 13% is too high, therefore Citi's DCF unreliable, therefore no reliance on Citi fairness opinion at all, therefore that's one reason why you can't rely on merger price at all.
Thank you.
So that's all I was going to propose saying orally on cost of debt, which leads me to the weighting of the competing factors. And here again, beyond what we've said in writing, just one or 2 points to make. The first point is that, as I've already indicated, the Court of Appeal does not identify anything beyond those features that I've already said that the judge failed to identify.
This is your fourth item, is that
yes,
right?
Yes.
Because 2 and 3 don't seem to lead anywhere.
No, they don't. So it's not a case of the Court of Appeal identifying here's a relevant consideration that the judge ignored. They identify all of the same considerations, but simply take a different view to the judge as to the weighting to be given to those considerations, which immediately, in our respectful submission, offends the principles applicable to appellate interference. But to the extent that a rationale is provided for departing from the judge's evaluation, the focus in the Court of Appeal's judgment is on the particular words used by the judge in paragraph 340D of his judgment at page 435, where the judge commented, having recorded Miss Glass's approach, which was to discount merger price by 60% to a 40% weighting, that he had identified further problems with the merger process, and so therefore that weighting needed to be adjusted. And he concludes in this paragraph, for the reasons I have given, these additional problems do not substantially undermine the merger process, and so I regard them as only requiring a small additional discount. Now, the Court of Appeal focuses on that last sentence and then compares the fact that Miss Glass had given merger price a 40% weighting and the judge ultimately gave merger price a 45% weighting, and concludes that the judge must have gone wrong because he cannot, on the one hand, have found that a small additional discount was required, while at the same time increasing the weighting for merger price from 40 to 45%. Now, again, with respect, this is an example of the Court of Appeal focusing in on one particular aspect without considering the position in the round and against the other findings made by the judge. So, for example, in the immediately preceding subparagraph, 340C, again on page 4, it begins on 435, but the relevant passage is on 435. Having identified some of the other deficiencies in the merger price, the judge identifies some countervailing factors. And if one looks about 10 lines down on page 435, there's a sentence beginning on the right-hand side of the page, on balance. And the judge concludes, on balance, these factors seem to me to justify giving some additional weight to the merger price, but not to prefer it to the exclusion of the adjusted market price. And then he then relies on Miss Glass's evidence again, and later on in that paragraph concludes that there's justification for giving preference to the merger price. And he returns to this question over the page at 436. In letter E, he concludes that a further discount needs to be made to market price. And then at F, he concludes that it's appropriate to apply a significant discount to the DCF valuation. He finds that Miss Glass's approach is generally reasonable but requires some adjustment to reflect the greater risk that I attribute to the market-based valuations, in particular to the adjusted market price. He finds that he does not disagree with Miss Glass's core proposition that in this case the market-based valuation should be given substantially greater weight than the DCF valuation. And of course that's completely reversed by the Court of Appeal, that outcome. But I do consider that she has, to a small extent, underrated the risk associated with her analysis of the merger price, and to a greater extent the adjusted market price, so that it is appropriate to make a modest adjustment to reduce the weighting given to the market-based valuations and increase the relative weight to be given to the DCF valuation, which is to be used to check and test the market-based valuations. So, what the judge is doing here is he's looking at all three different valuation methodologies, but then when he comes to F, he's weighing the market-derived valuation methodologies, market price and merger price, together as against the DCF valuation, and he's concluding that he needs to increase the relative weight to be given to the DCF valuation. And what he then says at G is, balancing out all these various factors, I conclude that the market-based valuation should be given a combined weight of 75% and the DCF valuation a weight of 25%. So he starts at market-derived valuations against DCF, and then having made that finding, he then divides the 75% for the market-based valuations, 45% to merger, and 30% to market. Now, a number of points there. The first is, to an extent, what was he supposed to do based on his findings? He has found that merger price should receive a greater weighting than market price, but that the two market-derived valuation methodologies, merger and market, should together receive a relatively lower weighting than the DCF valuation. So, starting with that latter conclusion, he reduces the weight given to the two market-derived valuation methodologies to 75% and increases the weighting, the relative weighting, given to the DCF valuation from 20% to 25. Having done that, he could not, as a matter of mathematics, have reduced both weightings to merger and market price to reflect his other findings and still get them to add up to 75%. Because they started at 40%, and he now has to, his overarching conclusion is that there has to be greater relative weight given to DCF as against the two market-derived valuations, which is how he gets to the 75-25. Having done that, he then has to do something with the 75. And of course, he can't reduce both of those and lead to a result that differs actually from the one that he gets to. And it is perhaps important here, my lords, to look at paragraph H, the next paragraph, where he gives further explanation as to the approach that he is adopting. And perhaps I'll just invite my lords to read H, please. And my lords will see that the judge has emphasised by putting the word in italics, relative, that he's giving the DCF valuation an increased relative weighting. So his core findings are DCF should have a greater relative weighting, but that market-derived valuation should have the greater weighting still, hence 75-25. Merger price should have more weighting than market price, differing from Miss Glass, who had given them both 40%. And so he goes 45% for merger and finds 30% for market. But of course, by emphasising the word relative, and of course, as he says, he's balancing all of these various factors and trying then to come up with percentages for weightings that reflect his findings, he's giving the DCF valuation an increased relative weighting. And my lords, that's what he's done. Not just by increasing it from 20 to 25, so that it's 25 versus 75 rather than 20 versus 80, as Miss Glass had said was the correct weighting. But 25 as against 45, so 25% DCF, 45% for merger, does give the DCF weighting, or the DCF valuation, forgive me, a relative greater weighting as against merger price. 25 as against 45 gives DCF a relative greater weighting than 20 as against 40 on Miss Glass's figures.
When he says at H Roman 1, towards the foot of 436, that he starts by following Miss Glass's methodology of blending, is that a reference back essentially to 338A at 429, where we see in the parenthesis that he treats her effectively as first adopting an 80-20 as between market and DCF?
Yes.
She split her 80 equally 40-40, and he's adjusting that by taking the market element down to 75 and then redistributing it as between the market factors in a different way. Is that what he was doing?
My lord, yes. With the result that his percentage weightings reflect his conclusions in a way that the court of appeal, with respect, misunderstood and concluded that they did not. Because his weightings do give effect to his conclusion. First, reduce the weighting between market-based methodologies and DCF. Second, reduce weighting of market as against merger. But third, ensure that DCF has a relatively higher weighting, not only against the two combined.
The trouble is that not all his conclusions can in fact be reconciled, because one of them was that there should be a slightly lower weighting to the merger.
Well, unless, of course,
something has to give in the conclusions he reached, and
well, other than this, my lord, I mean, there are 2 points. One, he has to do his best in the round to give effect to the conclusions, and secondly, if you were to look at the position, or ask the question, has the merger price been given a relatively lower weighting as against DCF? Then it has. Because although it's been increased from 40 to 45, DCF has been increased from 20 to 25. So relative to each other, the weighting afforded to merger price has been reduced. And of course, the judge is not saying that the weighting of merger should be reduced as against and relative to market price. On the contrary, as my Lord Justice Popwell just identified, the judge found that market price should have its relative weighting reduced, both as against DCF and as against merger price. What the judge has said is that there should be a relative decrease in merger price and a relative increase in DCF, and his figures actually is figures.
Yeah, okay.
do give effect to that.
Again, can you just pinpoint for me where the Court of Appeal make the point that his findings, that his ultimate conclusions don't reflect his findings?
So that, I think, is paragraph 146, Roman 1, which is at page 109.
Your point is that 25 relative to 45 is greater than 20 relative to 40.
Yes.
So he has discounted the merger price, you say, compared with the DCF.
My Lord, yes. And he hasn't spelled it out in the way that I've just done. He says one has to look at the position in the round and balancing all these various factors. But when one reads his judgment fairly, it's pretty clear in our submission what he was doing. Now, the final point, I think, on...
Sorry, so hold you up. Should we look at Roman 2 over the page?
Oh, yes, of course, forgive me.
Where the Court of Appeal also addressed this point.
Yes, forgive me, I should have given you that reference as well, my Lord. Thank you. Now, my Lords, the last short point really on weighting, I've made the point that the Court of Appeal failed to apply the principles which it otherwise correctly identified when simply substituting its own view as to the weightings to be given to the various defects in the merger process for those of the judge. But the final point related to that is that the Court of Appeal also ignored, or at least failed to give sufficient weight to, in a way that the judge did not, the powerful factors that pointed in favour of the reliability of the merger price. And I've touched upon some of these already. Perhaps can I just highlight 4. The first is that the buyer group held only 5.6% of the shares in the company. The second is that, save for 2.2%, those shareholders who voted or who were deemed to have voted in favour of the merger at the merger price, so 97.8%. The third point is that those shareholders who voted in favour included very many large, sophisticated institutional shareholders who, as the judge found, can be expected to have been able to form a view as to what the true value of their shareholding in the company was. And the fourth point is that the company had been on the market for something like a year before the merger was finally approved. And I'll just give my lord the reference that the judge's key findings in that regard are at paragraphs 156 to 157 of his judgment, beginning at page 321. And his conclusion, we say a correct conclusion, and at the very least one that could not be said to have been plainly wrong, was that these were significant factors that support reliance on the merger price.
The conclusion is at 157?
My lord, yes.
Thank you.
Now, the Court of Appeal's answer to this is at page 117. So I should also refer to paragraph 181 in the judge's judgment as well.
Just before you go there, at 176, the judge's judgment at 334, he seems to have placed reliance also on the views of the proxy firms.
Yes. Yes, he does.
Do you rely on that?
Yes, I drew attention to 4 particular points upon which I place particular emphasis, but I of course rely on all of the factors that the judge identified as supporting the merger price.
Thank you.
Yes, and I should have given my lords the reference that the conclusions are summarised at paragraph 181 on page 336.
The Court of Appeal response at 117.
The Court of Appeal's response at 117 is in Roman 7 and 8. And my lords will understand the submission that we make about that is an impermissible approach of the Court of Appeal, effectively just seeking to substitute its own weighing of these factors and their relative importance for those of an experienced trial judge, without actually identifying how it is in terms that the judge is said to have been plainly wrong. The judge weighed all of these factors and he formed the view that he did.
I mean, another factor that might be said to be some support for the merger price was that it wasn't that far off from the adjusted market price, which the Court of Appeal themselves concluded it was reasonable to take account of.
My lord, yes. And one's looking forward to the second round of appeal to which I'm...
There seems to be some incoherence in their approach. That they knock out one of the market valuations, but not the other.
Yes. And you know, I'm trying not to use the phrase island hopping too much. I'm sure I probably already have done, but...
No, well, I think appeal courts have heard, I think Well, Justice Lewison has something to answer for with that. Number of times it's been cited.
I should try and think of a more elegant, if that's possible, phrase, or at least a different one. But it is the difficulties of, if I put it this way, of just focusing on particular elements of the assessment, rather than standing back and, as the judge did, looking at the position as a whole. And that is the difficulty here, is that the Court of Appeal simply fails to have done that. Whereas what one sees from the judge's judgment with respect is the opposite, is a very careful weighing of the different factors. And he, of course, found, that there were problems with the merger price. He found that there were problems with the market price and with the DCF, but then looked at the position in the round, whereas, and I must move to ground two, what the Court of Appeal did was to cherry pick, probably no better phrase, but to focus in on particular aspects or sub-elements of a calculation, and then on the basis of that, to start dismissing the city fairness opinion and then ultimately the merger price altogether, without actually looking at the position in the round as the judge did. My Lords, we've said in our written case, and given the time I should probably not seek to develop it any further, that the Court of Appeal, in reaching the conclusions that it did, also seems to have sought to impose a new and unfair burden on the company, that if a company wishes to rely on merger price, it has to be particularly transparent on, and it will be subjected to what the Court of Appeal described as heightened scrutiny. To the extent that we say anything about that, we say that the Court of Appeal was wrong, and the judge was right, and that what, if any, weight to be given to the merger price, as with any other valuation methodology, will depend on the facts. And
it's in your case a paragraph.
I'm sorry.
It's in your case.
It is
a paragraph.
A paragraph. Forgive me. 6.20.
Thank you. Page.
Yes, although we also return to it at 6.47.
Thank you.
So, my Lords, can I turn then to ground two, which obviously follows closely on from ground one. The approach of the Court of Appeal here, as we've seen, was first of all reject reducing the weight to be given to market price, and to say that no weight should be given to it at all. Secondly, to find that the judge's weighting of 30% afforded to market price fell within the range of decisions reasonably open to him. And then to find that given that no weight could be placed on merger price, it followed, said the Court of Appeal, that 70% should be given to the DCF valuation. And, my Lords, the most we see by way of explanation as to why that should be is to be found in paragraph 245 of the Court of Appeal's judgment at page 164. And my Lords, with respect, that's just about it in terms of reasoning as to why the weighting afforded to the DCF valuation should be increased from 25%, as found by the judge.
Were there arguments about what the weighting should be in the light of possible conclusions?
My Lord, no. I mean, obviously, there were, as one sees from the Court of Appeal's judgment, a whole range of grounds of appeal that could have led to very many different outcomes. It's fair to say that neither side really addressed this before the Court of Appeal. Certainly, the company did not put forward alternative propositions or arguments as to the weightings that might be given depending on which way the Court of Appeal determined the grounds of appeal. And insofar as the dissenters were concerned, their position was that 100% weighting should be given to the DCF valuation, and if not, a greater weighting than the judge, without saying what that weighting might be. So it's fair to
You say if the Court of Appeal were right to say no weight for merger, then it should be remitted. Get the balance, is that right? Or are you putting forward a different approach to?
Well, we of course say that if we succeed on ground 1 and ground 2, then the decision of the judge should be restored.
Right, so
if we only succeed on ground 2, then regrettably, and we don't approach this with any enthusiasm, that the position should be remitted for the proper weighting to be determined on the basis of a proper reasoned approach. And then our tertiary position is that we've identified what the board might do if it were prepared to grapple with the position itself, none of which, I might be forgiven for putting it this way, are terribly satisfactory.
And that's in your para 7.11, is it?
7.11, that's right,
Yeah.
7.11. There is a typographical error, I think, in 7.11c, which should refer to that it's the 45% previously allocated to merger price. Be divided equally, not 35%, so I must apologise for that.
It is in 7.12, does 30% refer to the market price rather than the merger price?
Yes.
Cool.
But is remission, is that a fallback after remission, or which is your preferred course of action?
Well, our primary position, as recorded in 7.13, is that the decision of the judge should be restored. Failing that, the matter should be remitted to the Grand Court, and failing that, we invite the board to apply one of the 3 approaches that we've identified as being reasonably open. Now,
I would have thought if all you're doing is knocking out one of 3 valuations, then if there's no other consideration, the logical thing is to redistribute it pro rata between the other 2, your option B.
well, that's why.
However, there might be other considerations, because then you should stand back and review what the interrelationship of those 2 valuations is, and what your consideration up to now suggests the relative weight between those should be in the new situation, where there's no other market-related
My Lord, with respect, yes, and that's why we've alighted upon the
remittal.
The proposal that we have, with something of a heavy heart.
Proceedings last even longer.
Yes, as I say, that's why it's with some reluctance. But that's the position we find ourselves in on the basis of the Court of Appeal's decision. So that's. I was looking at the Court of Appeal's justification for increasing the weighting for DCF valuation at paragraph 245, and I've made the submission that, with respect to the Court of Appeal, the reasoning there is, to say the least, somewhat thin, but it's also, with respect, wrong, because what the Court of Appeal seems to be saying is that by the time one gets to trial, because the court has evidence from the 2 rival experts on their competing DCF valuations, the uncertainties inherent in a DCF valuation can somehow be overlooked or have been resolved by that expert process. And of course, that's completely to overlook not only the reality of the position, but the expert evidence in this case and the findings made by the judge. And one immediately identifies the uncertainties in the DCF valuation methodology by recalling the somewhat stark figures that I gave to my lords towards the outset of my submissions. But merger price giving an indicative value of this company of perhaps 1.1 billion, and then Mr. Edwards for the dissenters on his 3 different DCF valuations going from about 1 billion to 5 billion to just under 20 billion. And actually at trial, not even saying which he preferred. Just saying, well, there you are, those are the 3 calculations. And yet the Court of Appeal dismisses that type of uncertainty, saying, well, by the time you get to trial, it's all been resolved by the expert process. Insofar as the judge is concerned, he accepted Miss Glass's explanation as to why DCF valuations were subject to serious uncertainties, and one sees that at paragraph 339A and 339C at page 433. He found that the discount to be applied to the relative weighting of the DCF valuation depended in part on the uncertainties attaching to the DCF valuation, while at the same time having regard to the relative uncertainties he'd identified as attaching to the market price and merger price. That's 339D. On page 431. And then, having identified those uncertainties, and the uncertainties are inherent to each of the 3 valuation methodologies, the judge then performs a holistic and comparative approach, considering the 3 valuation methodologies together and their relative reliability. And it's in that context that we then come back to the conclusions that we looked at earlier this morning about him deciding that he would give substantially greater weight to the market-based valuation methodologies, lesser relative weight to the DCF, although greater than Miss Glass had afforded it, and effectively using the DCF as a cross-check. And one immediately sees, by way of comparison, one of the principal difficulties with the Court of Appeal's approach was that it considered and rejected merger price without comparing how the various flaws and uncertainties that even it had found should be afforded greater weight, should be viewed relative to the defects and uncertainties in the other 2 valuation methodologies. It effectively boxed itself into a corner by knocking out the merger price altogether first, and then denying itself the opportunity to do that which the judge did, which is actually to weigh the 3 valuation methodologies and their relative uncertainties against each other. The last point perhaps to make on this is that, of course, the judge based himself in large part on the expert evidence of Miss Glass, whose evidence he generally preferred. She had given, as we've seen, primacy to the market-derived valuation methodologies and least relative weight to the DCF valuation. And the judge had provided reasons as to why he was preferring that evidence as against Mr. Edwards' evidence, who contended for an exclusively DCF-based valuation approach. The effect of the Court of Appeal's decision is to completely reverse and overturn that finding without any consideration being given or reasons provided as to why that conclusion were to be justified, and in particular, without identifying why the judge was plainly wrong to prefer Miss Glass's evidence as he did. Now, this won't weigh very much in the balance, but it's perhaps indicative of quite how far the Court of Appeal went wrong in this case. That the dissenting shareholders in their reply skeleton argument before the Court of Appeal, in seeking to answer some of the points that were being made by the company as to the appeal being essentially an attack on the judge's findings of fact based on the expert evidence, expressly said, is page 683 of the electronic bundle, paragraph 21, there is no appeal point on which the dissenting shareholders invite this court to reverse the judge's decision generally to prefer one expert over another. Recognising, as they must, that they had no prospect, based on the judge's findings, of successfully inviting the Court of Appeal to overturn and reverse the judge's decision generally to prefer one expert over another. And yet that's exactly what the Court of Appeal's decision does in its effect.
They don't do it expressly, but you say that that's what it amounts to.
It does, exactly.
Right.
It has to. The judge has heard the expert evidence, and the judge has formed the view, I prefer Miss Glass's evidence, I prefer her evaluative approach to considering the three valuation methodologies together. I prefer her approach to affording...
With a market bias.
Yes.
Yeah.
And he makes some adjustments, but relatively minor adjustments to her weightings. And that's completely overturned by the effect of the Court of Appeal's decision. My Lords, that's all I was proposing to say on ground 2. Ground 3 is a conditional ground of appeal in that it only arises if and to the extent that the weight to be afforded to market value is to be revisited. And we deal with it in our written case at paragraphs 8.1 to 8.6. Other than perhaps to note that this is with respect to another example of appellate overreach by the Court of Appeal and another impermissible interference in the findings of the trial judge, I propose saying no more about it, other than this. Ultimately, what the Court of Appeal seems to have said here is that general assistance can be obtained from market analyst reports, and ultimately what it characterised as the judge's error made no difference in the final analysis to the weighting that could be given to the market price. Well, one asks the question then, if ultimately that's the outcome, why was the Court of Appeal, if I can be forgiven for using the word tinkering, with the judge's findings, rather than standing back and saying, well, look, overall, the judge is not to be criticised in the findings that he made. My Lords, that leaves the adjustments to the DCF valuation that were made by the Court of Appeal, grounds 4 and 5. Ground 4 deals with module selling prices, and what the judge did in this regard is, first of all, set out the test to be satisfied before management projections could be given any weight. And he does that at paragraph 188 of his judgment at page 340. He then finds that the management projections had not been shown to be unreliable or unreasonable. And I'll just give my Lords the reference given the time. It's paragraph 8F, Roman 3, at page 200. And his fuller, more detailed reasoning for this conclusion is at paragraph 189.
Sorry, could you give those references again, please?
Forgive me, my Lord. It's paragraph 8F, Roman 3, at page 200, which is in the summary of his conclusions at the outset of his judgment. And his fuller, more detailed reasoning for his conclusion is at paragraph 189 on page 341.
Thank you.
In reaching that conclusion, the judge relied on a number of factors, including, first, that the management projections had been prepared by those in the company with an in-depth knowledge of its business. That's paragraph 189B. Second, that given that the knowledge and expertise within the company, where the issue was not company-specific but industry-specific, and while the views of the industry experts were to be given substantial weight, the views of management should also be given weight, and what weight would depend on the particular issue and the evidence on that issue. And that's paragraph 189I. And thirdly, by way of emphasis, I of course rely on all of the reasons he gave as to why the management projections should be relied upon, but these 3 points by way of emphasis. The management projections have been reviewed by the experts, and in Miss Glass's opinion, which he accepted, they were, save for limited exceptions, in the round reasonable. And that's paragraph 189D at page 342. In relation to the average selling price, ASP in particular, the judge found that the evidence, including the expert evidence, established that there was a range of reasonable approaches and forecasts, and that expert evidence did not demonstrate that the management projections were clearly or likely to be in error. And one sees that at paragraph 217E at page 369. And I, of course, rely on this paragraph as a whole, but the reference to the range of potentially reasonable approaches is in the very last sentence. And, my lords, in our submission, that's a classic evaluative judgment of the type often seen in a valuation context, where one sees the use of a range to reflect and accommodate the existence of a variety of valid and reasonable opinions on a valuation, or here, a valuation input. So that's what the judge found, taking it at something of a canter. The Court of Appeal suggested, first of all, that the judge may have applied the wrong test, although there's perhaps not much, if anything, between them here other than points of emphasis. More substantively, what the Court of Appeal found was that, having rejected the opinions of the industry experts, as he did, the judge then favoured Miss Glass's analysis, subject to rejecting her inclusion of what was called the sunshot figures. But that, having favoured Miss Glass's analysis, he was not entitled to find that the management projections were reasonable and capable of being used in the DCF valuation. Instead, what the Court of Appeal said the judge was bound to have done, based on his own findings, was to have used Miss Glass's figures, excluding sunshot, but should not then have used a linear rate of decline from 2021 onwards. And my lords will see those conclusions at paragraphs 171 to 176 of the Court of Appeal's judgment, starting at page 131. Now, my lords, dealing with those points, in truth, as I've indicated, there seems to be little, if anything, between the Court of Appeal and the judge as to the applicable test. The starting point is the general reliability test. If the management projections pass that test, then the court should be slow to interfere with or adjust the management projections on the basis of the expert evidence, unless there's some clear basis for doing so. The two courts express themselves slightly differently on that point, but that's the gravamen in our submission of what the two courts are saying. Whatever the test, if there is a substantive difference, we say that the Court of Appeal was wrong to interfere with the judge's assessment of the evidence. First, as the judge recognised but the Court of Appeal did not, in this, as with so many aspects of valuation, there's no single correct answer. Instead, there's likely to be a range of reasonable answers. Here, the judge found that the management projections for average selling prices fell within that reasonable range, relying on the analysis of Miss Glass and also his other conclusions about the general reliability of the management projections. That was, in our submission, perfectly permissible. The judge found that Miss Glass's analysis supported the management projections in the sense of showing them to be within range. In doing so, he self-evidently, in our submission, did not then have to find that Miss Glass's figures were the same as the management projections in order to find, as he did, that the former lent support to the reasonableness of the latter. He simply says that Miss Glass's figures and her approach and analysis support the reasonableness of the figures being used by the management in their own projections. And that conclusion Lords is lent further support by a fuller and better understanding of what Miss Glass was doing. She was not providing expert evidence on average selling prices herself in the same way as the industry experts were, but an analysis as a valuer of the various third-party sources going to what a reasonable projection of the average selling prices might be. And the idea, and this is the idea that underpins the Court of Appeal's decision, that having preferred Miss Glass's analysis, the judge was bound to use Miss Glass's figure, is with respect just wrong. It's wrong in principle, given the exercise the judge is doing. He's using the expert evidence to support his conclusion that the management projections were within range. He's not then bound, having preferred that expert's approach and her figures, to use her figures in preference to the management projections themselves. And the reasonableness, if further support for the judge's decision here is required, of that decision is perhaps demonstrated that Miss Glass herself made the point that her adjustments to the management projections made only a modest difference to her overall opinion on fair value, something like 23 cents after minority discount. And that's paragraphs 348 to 349 of her supplementary report at page 5145. So again, in our submission, the Court of Appeal erred. There was no basis for finding that the judge was plainly wrong. He wasn't plainly wrong.
Forgive me for interrupting. That was her evidence taking into account Sunshot, was it?
It was, my lord, yes.
So
it would be a bigger difference. You're quite right.
It would be a bigger difference
if Sunshot is
if the judge were right in saying she was wrong to take into account Sunshot.
That's right. But figures aside, it's still likely to be relatively modest, and it comes back to the overarching point, which is perhaps the better one, which is, again, one's looking at a single input as part of a much larger valuation methodology. And what the judge is doing, and what the Court of Appeal failed to do, is to look at the position in the round and in effect take the rough with the smooth, which we see even more so in the next and final ground of appeal, ground 5, which is concerned with management projections on capacity factor. Now, capacity factor, here the judge found that it appeared that the management projections of a 13.7% capacity factor was probably below a reasonable forecast. And Miss Glass, as the judge noted, accepted that was probably the case in her cross-examination. He also found that the evidence does not establish what a reliable and reasonable higher estimate should be, and therefore what alternative estimate the court can properly use. He was not prepared to draw adverse inferences against the company in this regard. And again, on balance, he found Dr. Goffrey's evidence as supported by Miss Glass's reasonableness tests to be preferred to Mr. Russo's analysis, and also found Miss Glass's analysis and explanations to be convincing, and on that basis concluded that the forecasts for capacity factor in the management projections should be used. And one finds that at paragraph 249 of his judgment, at paragraph 383. One sees earlier in his judgment at paragraph 246 that the judge accepted Miss Glass's analysis and explanations, and ultimately her view was that the management projections were reasonable and should be accepted. And that's at page 380. Where he deals in that paragraph with Miss Glass's acceptance of a number of the management projections. And one sees capacity factor towards the end of that paragraph. Now, what the Court of Appeal found at paragraph 188 of its judgment was that the judge found that the management projections for capacity factor was probably too low, and that was a finding that it was too low, that the management projection was too low. And if that was his finding, as the Court of Appeal said it was, he could not then rely on the management projection for capacity factor in his DCF. And instead, what the Court of Appeal said is that the judge would have to do his best and form his own view as to what the appropriate capacity factor was. And the Court of Appeal then undertook that exercise itself by taking the actual capacity factor for 2015 and then projecting it would increase by 0.05% per year from 2017. Now, we again say with respect the Court of Appeal erred here. Firstly, we say it's wrong for the Court of Appeal to have found that, having found that the management projection capacity factor appeared probably too low, the judge had in fact found that it was too low. But secondly, in any event, it was wrong for the Court of Appeal to find that the judge was precluded from using the management projection for capacity factor in the DCF valuation. The judge was entitled to find, as he did, that there was no good evidential basis for selecting a figure other than the management projections. Even if the management projection figure appeared too low, there was at least some basis for it, as he found there was in the analysis of Miss Glass and Dr. Goffrey, which he accepted. That analysis, so the analysis of Miss Glass and also of Dr. Goffrey, included the point that Mr. Russo, the expert for the dissenters, in suggesting that an increased capacity factor should be taken, had assumed the use of trackers without considering the increased costs and curtailment issues raised by their use. So this is a counterbalancing point again. So the capacity factor is the capacity of the installation of solar panels to produce electricity. Mr. Russo says you should assume an increased capacity factor as there's a greater use over time as the technology is rolled out of trackers. Literally, as I understand it, technology which allows the solar panels to move to track the sun. So that would then increase the capacity. But the countervailing points to that raised by Miss Glass was, well, increased use of trackers means increased costs. And there's also a potential curtailment issue, which is the maximum capacity to put your electricity into the market. And indeed, when Miss Glass accepted in cross-examination that the capacity factor might be too low, that concession was based on, as the judge found, an increased use of trackers going forward. But in any event, the capacity factor was but one factor to take into account in the broader DCF calculation. And when one talks about the judge accepting Miss Glass's analysis and approach, there are the particular points to which I've already referred about the countervailing factors of increased capacity. But there's a more general point in her approach as well, when it comes to the use of the management projections. So if we turn up, please, page 5144, she explains her approach to the management projections in paragraphs 342 and 343 of her supplemental report.
Sorry, could you give me the page again? I'm so sorry.
5144.
514.
5144.
Yep.
I may have misspoken. is obviously important because it's this approach and analysis that the judge accepts. And what Ms Glass is saying there, really quite clearly and perfectly understandably, is that as a valuer coming to the piece after the event and considering the management projections, one can identify differences in the assumptions and calculations that you might make as a valuer as against those made by management. And when you identify those differences, you can do one of two things. You can either go through and make adjustments for all of the differences where they exist, or, looking at things in the round, you could take the position that, as she puts it, the lows offset the highs, so that one balances out the other. If you're otherwise satisfied, as she was, that the management projections were reasonable. So while it's true that there were suggestions that the capacity factor was too low in the management projections, overall that was one of the lows that was balanced out by the highs.
It's not just perhaps a question of balancing, but recognising the uncertainty inherent in the exercise.
Yes, my lord, yes. It's a multifaceted, multifactorial.
Well, it does look like tinkering for the Court of Appeal to fiddle around with one aspect of the complicated valuation by making up some numbers of their own.
Well, my lord, if my say so, puts it more bluntly than I'd be brave enough to, but that's the gravamen of my submission. Yes, they've plucked figures from thin air, and an approach from thin air that derives no support in either side's expert evidence. Having found that because the judge, on their approach, was not entitled to use the management projections, he had to come up with something, overlooking that the evidence before the judge which he accepted, in particular from Miss Glass, was one can quibble or tinker with this input here or that input there. But if standing back, you take the view as a valuer, as Miss Glass did, that the projections overall and in the round together are reasonable and produce a reasonable outcome, then you don't tinker. And with respect, the judge was right to do what he did, which was not to accept any invitation or temptation to tinker, but to say, I recognise that there's evidence here which suggests this projection might be too low. But when looked at in the round, the management projections are reasonable, and therefore it's reasonable to take these management projections in the DCF valuation. My lords, just so you have it, the particular conclusion, this is obviously a general conclusion about the reliability of the management projections and Ms Glass's approach. The particular conclusions on capacity factor, I'll just give my lords the reference given the time, are at page 4635 to 4642. My lords, I fear I've taken those last two grounds at something of a canter necessarily, given the time, but the reasons I've articulated orally and developed in the written case, those are the reasons why, with respect, we invite the board to allow this appeal.
Thank you. Anything further? Thank you, Mr. Chapman. We're grateful. Mr. Howard.
Suggest this appeal is brought against a carefully and thoroughly reasoned judgment of the Cayman Islands Court of Appeal, and it in fact adopts an orthodox approach, and in our submission there is no reason why this court should interfere. Now, the central focus of the appeal concerns the merger price, and as you know, the judge at first instance had suggested that a 45% weighting should be attached to the merger price, and the Court of Appeal regarded the merger price as unreliable as an indicia of fair value. And that's what one's got to remember. What we're searching for here is fair value. Now, although it's been spoken about as a merger price, the reality was this was a management-led buyout with the company's chairman, chief executive and founder, Mr. Gao, having a prominent position in the buyer group. And the merger was a merger with an SPV created by the buyer group. Mr. Gao, the company's own statements, and we don't need to turn it up, but Form 20F is at 1464. Actually, it probably is worth just looking at that. So yes, that's the beginning of the document 1464. And if we go to 1483, where you can see the relevant statement, you see the paragraph midway down the page, our business heading depends substantially on the continuing efforts of our executive officers, and our business may be severely disrupted if we lose their services. Our future success depends substantially on the continued services of our executive officers, especially Mr. Gao, our chairman and CEO. If one or more of our executives were unable or unwilling to continue, we might not be able to replace them. Our business may be severely disrupted. Our financial condition and results of operations may be materially and adversely affected, and so on. Now, the importance of that is that Mr. Gao and his team had made it clear that they were committed to supporting the buyers' group's proposal only. In other words, they would not support any alternative bid. And that's very important when one comes to look at the Court of Appeal's criticisms of the merger process which took place here. Now, I'm not going to spend time on the correct approach of an appellate court to the reviewing a first instance judgment. Your lordships are very familiar with it, and what's more, it's not in dispute that the Court of Appeal correctly set out the principles. So before I come on to the substance, I want to say something about Section 238 cases. Now, as you know, Section 238 has similarities with similar provisions in Delaware, and I think some of you know from an appeal I was in earlier this year, there are similar provisions in Bermuda. That's the Jardine case. I think some of you were sitting on that, as I recall. Now, the fair value is, as it were, the quid pro quo for the company or the majority shareholders having the right to force the sale of a shareholder's shares. Now, one of the things that is clear is that in both the Delaware jurisprudence and the jurisprudence in the Cayman Islands, where there have been a number of these cases, there is no particular methodology which takes precedence. So, as you know, the ways in which people seek to assess the value is by looking at the fair value, is by looking at the merger price and the market price, and then a discounted cash flow analysis. Now, the difficulties that emerge with both the merger approach, merger price, and the market price is they are very dependent, particularly the merger price, on whether the process has been properly followed. Now, you've been referred to various of the authorities. I don't propose to take time on those, but...
There's a difference, isn't there, between a situation where there's an entrenched majority who, unless there's a fair value, can exploit the minority, so to speak. And as I understand it, this case, where it just happens to be that the dissenters were only 2%, but there was no inbuilt majority in favour of the buyout. It was just what the vast majority of the shareholders chose.
Your Lordship is right that so a situation like, for instance, Jardine, I think the Jardine company, or the main holding company, I think controlled 85% or something of that order of the shares, then it is inevitable that the merger will go through. In this case, you can say, well, it wasn't inevitable because the buyer group only controlled, or Mr. Gao and his wife controlled 5 to 6% of the shares. But that doesn't lead to the conclusion that the merger price is necessarily the fair price, the fair value, because, and we'll come on to that, there may be all sorts of reasons why shareholders vote or don't vote. So, for instance, here, actually about almost half didn't vote at all. They're deemed to vote in favour, but they didn't actually vote. Now, there may be a number of reasons why people vote. It may be, for instance, if you're an institution, your mandate doesn't allow you or requires you to vote in favour of what the management are proposing. Maybe you're also influenced by what the management are recommending, and here in the case of City, that you've got a fair value opinion. Now, if the management recommendation is not appropriate, as it turns out, or the City, the independent financier's opinion is not reliable, then that is the basis on which one can reassess it. Equally, if the merger process has not been designed to allow competitive bidders to come in, indeed may have put a dampener on that, that may suggest that the merger price is not one which is the fair value.
I don't see why it suggests that. I can see it might mean that you can't necessarily be so confident that the merger price does reflect fair value.
Well,
but it doesn't inherently suggest the opposite, does it?
No, my Lord, that's a fair point. But you've got to remember, if you're putting forward, what happens in this process is the company is putting forward the merger price and saying that is fair value. And it's this is an adversarial process, and it's for the company putting forward the merger price to justify that is fair. And what I'm saying is, if you don't follow a fair process, for instance, where there is an opportunity for others to come in and the court can't be satisfied about that, then I would suggest the court can't be satisfied that the merger price does reflect fair value.
Well, it may or may not be able to. Obviously, it won't have the benefit of that particular support, but it does seem to risk putting it too high to make it a sort of condition of putting weight on the merger price that you've gone through this process.
Sorry, I didn't catch what you...
It would put it too high, wouldn't it, to make it a sort of condition of reliance on the merger price, that you followed this optimum process.
My Lord, I don't think the jurisprudence is saying it's a condition in the sense that you say, so, and we're not saying that, so that if you
just
fail,
weighting factor.
You've got to look at all the circumstances to decide if the merger price is reliable as an indicator of fair value. With all these things, that's what you're looking at, to see to what extent can I rely on this as an indicator of fair value. And so you can have situations, and I think there are authorities in the bundle, where some of the process was not ideal, but the court has said, well, don't think ultimately that matters very much, so we can still rely on it. Equally, if you have an extreme failure, and we would suggest there were extreme failures in this case, that leads you to conclude that I can't place weight on the merger price as indicating fair value. But it is, and that's what the Court of Appeal said, it is a question of looking at the nature of the failings. And what the Court of Appeal said was the judge's own findings as to the failings meant that the merger price couldn't be relied on as a reasonable indicator of fair value.
At the moment, what I'm sure you'll be addressing is what seems to be a major weakness of the Court of Appeal's approach is that they looked at it as a sort of all or nothing thing for the merger, reliability of the merger valuation. Yeah. They didn't look at it in comparison with the reliability of the other valuations and how they all fitted together.
Well, one needs to, with Stret one, I think one needs to separate out different points. So, I mean, the issue before what were the issues before the Court of Appeal? It was the dissenters' appeal. The dissenters' appeal was that 100% weighting should be given to the discounted cash flow and no weighting should be given to the merger and the market price. So, so as part of it, the Court of Appeal was considering the arguments as to whether the merger price and the market price should be knocked out. They concluded that the merger price should be knocked out because it was unreliable as an indicator of fair value. A separate question was then, what do we do next? Which goes to the weighting argument. In my submission, one needs to look at these separately. Now, once the Court of Appeal got to the situation where they said we are knocking out the merger price, one then had to consider what were the arguments in front of them. Now, the only argument in front of them was the dissenters' argument that the market price was unreliable and should be knocked out, and the company's argument was no, it shouldn't. But as the Court of Appeal said, nobody was suggesting the weighting applied to the market price should be changed. Sorry, the company wasn't saying it should be changed. We were saying it should be knocked out.
Yeah, but they didn't go with that. And what they didn't then do was to consider how the keeping in the market price and knocking out the merger price were mutually consistent, or how that should fit together.
Well, my Lord, that is, in a way, a product of the way the case was argued in front of them. And I think that I would suggest that
it may have been, but it led to seems to be an incoherent result.
Well, my Lord, you could say, as I think your Lordship was saying, this whole question of blending these different approaches is incoherent, and particularly blending the merger price and the market price as well as the DCF. And if you stand back and just remind you what they are, merger price, you know, is the price agreed. The market price is not, in fact, certainly in this case, the price at which the shares are being traded in the market.
It's a sort of projected market price.
It's right. It's an assessment. Now, a discount...
It has to be adjusted to take account of the whole question of merger.
Sorry?
It has to be adjusted to take account of the whole fact of the
It has to be adjusted because you're trying to work out what the market price of the shares would be absent.
Yeah.
Yeah, because you're not trying to give value by reference to the merger. You're just trying to work out what the value of the shares is, as it were, independently. But because this is the shares are being traded for a year or so in the light of the merger, you've now got to disaggregate, as it were, that information from the price and project a price. But there's an oddity in blending a merger and market price, and I don't think that's ever been done in any of the authorities where you had both merger and market.
But is it odd that, as I understand it, the justification for blending is that you have different methodologies, and if you take any one of them, it's subject to uncertainties. You may say, you look at each of them, and you can't be satisfied that it is 100% reliable, and you can take it on its own. And by blending, you're seeking to attribute some weighting to the uncertainties in each of the,
Yeah.
in our case, 3 methodologies. And if that is a coherent basis for doing blending at all, why does it become incoherent to blend a market price, adjusted trading price, and a merger price, if there are just uncertainties about both of them?
I want to stress, none of this actually arises in relation to the issues today. But the reason I would suggest that it is potentially incoherent is that if you decide the merger price is a reasonable proxy for fair value, then looking at the blending it with a market price which is lower than the merger price, and so is discounting the sum that is payable for the shares. That's what I would suggest doesn't actually make sense. That because they're both meant to reflect the market. And if you say, particularly if the company, let's say the company says the value of the shares is 10, and it's incoherent to say that the fair value for the shares is lower than 10. That's what I would suggest. It doesn't make any sense if that's what the company or the people who were proposing the merger were prepared to pay. It's odd to say that fair value is actually less than they were prepared to pay.
Well, it'd certainly be incoherent to treat either of them as 100% and then say the other one can be right.
Yeah.
But if you have uncertainties, I'm thinking of myself, I have difficulty in seeing why you shouldn't say I'll rely on both of them and find something in between the two.
But for present purposes, the judge at first instance applied the blended approach. So what was the issue before the Court of Appeal? The issue before the Court of Appeal was we weren't arguing that it's wrong as a matter of approach to have a blended approach. Our argument was that both the merger and the market were unreliable and therefore shouldn't go into the mix, or if they do go into the mix, the DCF should be the preponderance. Now, the Court of Appeal, on this point, agreed with us on the merger price being unreliable. We say they were right about that. So when you get to the question of weighting and what the Court of Appeal should then have done, and I'm obviously going to come back to this later, but we say the issue that was before them was actually quite simple, that as they recite, nobody was arguing for an increase in the percentage weighting to be attributed to market. The company, and my learned friend acknowledges, the company didn't argue for that. So that the only, as it were, case in town was reduce market from 30% to something lower. That was our argument. They rejected that, but said, okay, we're sticking with 30%. So as a matter of logic, what was left was the discounted cash flow. Well,
that was right if you stick with 30%, but was that rational? What they didn't stand back from and think, is it a sensible result to say I'm going to combine 30% and a valuation which is lower than the merger price, which you suggest doesn't make much sense anyway, and then combine that with one which is 3 times higher, and say that the combination of those two is somehow magically going to produce an accurate value. It seems to me crazy.
No, with respect, it isn't. And I think Lord Justice Popplewell really explained why it isn't. If you say if you're left here with 2, which is the market and the DCF, if your conclusion is, well, I'm not going to say one carries the day on its own, and there's uncertainties about both, and I'm going to therefore put them both into the mix. And what comes out of the mix is, as it were, a compromise, which is what I regard as the fair value. And that's what the Court of Appeal, that's what the judge had done below, but he'd just taken...
The judge, though, has done it on a much more nuanced basis, because he's first of all looked at what weight should be given to market considerations, and he's given them a predominance to that, and then he's adjusted that a bit. by relevance.
But
it's another thing when you knock out one market-based valuation, keep the other in, up the discounted cash value, and then somehow combine the two.
Well, but as I say, that is the product of the way the matter was argued before the Court of Appeal. So
nobody was arguing, putting the case, what happens if we take out the merger price?
I'm sorry.
Nobody was putting to the court an argument as to what was to happen if one element came out.
Well, they were, in the sense that the dissenters were.
Well, they were just saying all one. They weren't looking at what happens if one comes up and not the
Well, they were. That's not quite right. They were saying it's discounted cash flow 100% or the balance, the preponderance for the discounted cash flow. And the market price should be lower than the judge has given it. It should either be zero, but it certainly shouldn't be more than the 30%. No one was saying it should be more than 30%. It was open to the company to have argued, to put in a cross notice and said, a respondent's notice, and said, well, in the event that you knock out market, then merger should get a higher value, a higher proportion, or if you knock out merger, market should get a higher proportion. And that's what they should have done if that's what they were going to argue, as they appear to be now.
Well, there were so many different permutations, weren't there?
No, there weren't.
No?
There weren't, actually. That's the thing. It said there are, but there are only 4 permutations in this case. One is that we totally fail, in which case everything stayed as where it was. The next is we totally succeed. You knock out merger and market. You're just left with DCF. Then the only other 2 which would require to be addressed is what if you knock out merger as
One
happened.
of the others. Knock out one of the market related
That's
ones,
right.
not the other.
And the company chose not to make any submissions on that. They didn't seek to submit that in the circumstances where merger is knocked out, market should be increased. And so the Court of Appeal was entitled to say, I mean, that's what you've seen that they expressly recite that at paragraph 244 at page 164, I think it is.
It is.
Where they said there is no suggestion from any party that the weighting given to the market price should be increased. In any event, I would not think it right to do so in the light of the various limitations and uncertainties just mentioned. A weighting of 30% was within the range of decisions open to the judge, and I see no grounds on which we could properly interfere with that weighting, and so on.
The thing is, he was arriving at that rating on the basis that the merger element was going to be included. It doesn't follow that he would have given the same weighting if the merger price had been knocked out. That's why this whole approach, this part of the Court of Appeal's judgment, they seem to lose sight of how these things all interact with each other.
Well, I'm not sure that's right. The Court of Appeal, I mean, I don't think that's fair to the Court of Appeal. And the Court of Appeal was, I mean, if you look at 245, they say that given their view no weight can be placed on the merger, follows a 70% weighting should be given to the DCF. I see no difficulty in this. The company submitted before the judge and the court that a DCF is inherently subjective, and so on.
Well, it simply doesn't follow that because that a 70% weighting should be given to the DCF because no weight can be placed on the merger price.
Well,
that simply doesn't follow.
Well, no.
Is your point that in the context in which these arguments were being put, it was entirely rational for the Court of Appeal to do what they did because the only arguments facing them were either 100% DCF, which was the dissenters' position, or a reduced DCF, but certainly no more than a 30% market weighting, because that was what everybody was agreeing on market weighting.
Yes.
So in that context, you say that was rational for the Court of Appeal?
I do say that, and that it wasn't necessary in that context for the Court of Appeal to go back, which I think is what my Lord Legate is suggesting, and re-evaluate the whole thing again. They had a limited, as it were, menu in front of them. So we've jumped in rather at something that we were going to come to later, but no problem with that. If I can just introduce what I'm going to say about the merger price before the break quickly. I mean, what the Court of Appeal in relation to the merger price found was that on the judge's own findings, it wasn't open to the judge to give the 45% weighting to the merger price, and indeed it wasn't open to him to give any weighting to it at all in the light of the inadequacies that they refer to. And can I just take you to paragraph 148 for a very important observation by the Court of Appeal in relation to all of this. It's at page 118, I think, in the bundle. This is where they summarize the matters that they were looking at. So, on the facts of this case, given firstly the significant deficiencies in the market check process, secondly it was a management buyout with all the potential difficulties and conflicts of interest, third the material risk that Mr. Gow's position had a chilling effect on prospective bidders, four deficiencies in the fairness opinion, five, the concerns about the independence of the special committee and whether they were willing to act adversely, and six, the complete failure of the company to produce relevant evidence. I don't see any reliance can safely be placed on the merger process. And it's the next sentence that I would suggest is particularly important. The whole point of the protections and processes which have been developed in the Delaware jurisprudence and adopted in this jurisdiction is to give the court comfort that the merger price can be probative of fair value. And that's the critical question. When you look at the deficiencies, the question is the merger price, can you be comfortable it is probative of fair value? And in our submission, when we go through those criticisms and you look at them in their totality, the merger price cannot be relied on and can't give you comfort that it is probative of fair value. So I see the time. I'll develop those submissions this afternoon.
Thank you, Mr. Howard. We'll rise now. We'll sit again at